sexual harassment isn't really about sex. It's about the power imbalance.
Oh, okay.
So whenever you have a situation where, especially where a supervisor is engaging in sexualized conduct that may be making a subordinate feel uncomfortable just by the nature of the conduct, you want to stop that because it's the power imbalance that is working the problem there.
Hello, everybody, and welcome to another episode of NY100. Today, we are sitting in the beautiful White Plains, New York, not Brooklyn, not Manhattan. Yes, I said it, White Plains. Sitting with Gerry from Phillips and Associates, one of the top lawyer firms in New York. So, very excited to dive deep in this. Gerry, nice to finally meet you.
Good to meet you.
It's 9 a.m. here, and I just want to ask you, what do you do here at Phillips and Associates?
So Phillips and Associates is a plaintiff side employment discrimination and harassment firm, and all we do is employment discrimination and harassment cases on behalf of individuals. We don't represent companies. We only represent individual employees in their disputes with their employers. We are also a pure contingency firm, which is somewhat unique in our field.
I'm sorry. I got to double it down.
Sure.
What is pure contingency?
So pure contingency means that when we take on a client, the client doesn't pay us anything for fees unless we get a result for them.
Oh, okay.
We also back the client in terms of the costs of litigation. We front those costs.
Okay.
Now, ultimately, the client's responsible for the costs, not for the fees,
Okay.
but those typically come out of whatever recovery we get.
Okay.
Bill Phillips, my partner and the founder of the firm, has a saying, why, and a belief really as to why we are a pure contingency firm, which is we deal with a lot of people in difficult situations who lose their jobs.
Yeah,
And
so they have the funds.
yeah, you don't want to ask someone for a retainer when they've just lost their job. You're there to try to help them get to the next level, open the next door.
All right. That's great. And so, what exactly is discrimination in the workplace?
So employment discrimination in the workplace takes many forms, and luckily in our country and our state and even in New York City, there are a lot of laws that protect individuals against discrimination in the workplace. And basically, sort of giving you a broad definition, it's any time that a worker is treated differently in an unfavorable way compared to someone else because of an immutable characteristic, something that they can't control, their race, their gender, their ethnicity, their age, their disability, sexual orientation, gender identity, etc.
So, I'll dive into that a little later about
Sure.
actual source of harassment. And I want to get back to what you originally said. You only focus on employment law and discrimination.
Yeah.
So, what is the importance of specializing in one practice as opposed to generalizing being full service?
Yeah, well, I mean, in the law, it happens a lot that you have, specialties. It's just like in medicine, you do have internists who are sort of a little bit of general practitioners, and also in the law, you have solo practitioners that basically do kind of everything for individuals. They might even do some employment cases. They might do some, accident cases, but if you have a serious situation, like in a medical situation, you go to a specialist. In the law, you try to go to someone who understands the field. Employment law is, the reason I love employment law is because, there are a few reasons. One is that I really enjoy working with people and helping people, resolve disputes. But I also enjoy the complexity of employment law. It's very complex and dynamic and changing all the time. So unless you're really focused on it, you're not going to be on the top of your game, which you really want to be, because you're going up against big companies and big institutions. It's kind of a David and Goliath struggle. So, you want to be taking your A game.
You want to work with someone or work with a law firm that has special knowledge on this, because, as you said, you're taking on companies that have a lot of backing, they can afford, you know, the expense, really high-end lawyers. So
You want someone on your side that matches the knowledge base of, you know, your adversary. And so in employment law, though, there are smaller firms and there are larger firms. One of the things that makes us unique is that we're one of the largest plaintiff side employment firms. So we, you know, in our posture and our profile, we can, you know, stand toe to toe with an employment department of a large firm representing a company. We have a lot of attorneys, we litigate a lot of cases, we try a lot of cases. So, you know, we have that heft, if you will, within the employment sphere.
you mentioned that, again, this is a very large firm focusing on a niche topic like employment law and discrimination. But I'm very interested. So, what's your background? How did you become a lawyer?
Well, so, growing up, I was a loudmouth, so everyone I met said, you know, you should be a lawyer. So eventually I listened to them. I went to Columbia University undergrad, and then I went to Boston College Law School. And how I got into employment law is pretty much a fluke. You know, I was always, when I was thinking of going to law school, there was a very popular TV series called LA Law on at the time. And, you know, it was very sort of slick and glamorous lawyers in Los Angeles, you know. So as an undergrad, I'd studied political science and had a couple of professors who I worked for as a research assistant, and they were like, you should go into political science, you're great, you know. I really loved political science. And I was like, no, I want to go be a slick lawyer, you know. So I went to law school. And then when I got out of law school, from Boston College Law School, I really wanted to be like a, you know, high-powered commercial litigator, working at one of those big firms that I told you about, you know, representing companies and that kind of thing, doing big deals. And the way the legal industry works, when you're in law school, it's 3 years to go to law school. At the end of your second year, you become a summer associate at a firm, right? And basically you're like a law clerk, and they see how you're doing, and, you know, you see if you like the place, and then typically they make you an offer to start working there after you finish law school. So you go back for your third year of law school, then you finish, and then you start at this firm. So you're all set up, right, at the end of your second year, right? So I got a summer associate gig at this firm called Old Wine Conley. That was a spin-off from a big firm like Cravath, Swain & Moore that I mentioned before. And I did fine, and I got an offer to join them afterwards, but it was, you know, it was 1991, and the legal market tanked that year. It was like right at the edge of the recession. Service industries usually, you know, are at the tail end of a dip in the market. So, you know, so basically there were like no jobs, and the firm went under. Yeah, so they had just bought, just like, you know, gotten a big lease in the, you know, in a big building, and you know, and then all of a sudden, done. So, long story short, I finished law school. I don't have a job, and, you know, I'm coming back to New York City, where I was born and raised, from Boston. My wife is pregnant with my son, and it's like a disaster, and I'm scrambling to get a job. And I got a job at Corp Counsel's office, which is the city's attorneys, Office of the Corporation Counsel of the City of New York. It's like a big law firm, but on the public side. And basically all they do is defend the city, New York City, in every type of suit, right? And I just happened to be placed in the general litigation division that does a lot of employment discrimination work. And I really liked it a lot. So I worked there for 3 years, and then I went on.
I do want to go back into that. I think everybody, especially around that age of 20 to 27,
Yeah.
everybody has that life-defining moment, you know, something that comes off guard, hits you in the side, and, you know, what just happened? What's the next step? And I would like to, you know, dive back into that a little bit. So, you know, when you thought you had everything set up, everything was in, you did the work.
Right.
An external first came in and kind of changed the situation. So what was your mindset when you came back home, now you had a your pregnant wife, no job. So what was the can you take me back to that mindset? What was your mindset to okay? How do I get out of
Yeah,
this?
I always say that adversity is an opportunity to overcome. So,
Like that.
you. I'm not going to lie to you. I wasn't thrilled about the fact that, I had this vision of being, this hotshot lawyer making, starting at the time probably like would have been $100,000 or whatever, and I had to take this job with the city, making not a lot of money, but it turned out to be a blessing in disguise because when you're a young lawyer at a big firm, you make a lot of money, but it's like golden handcuffs. You don't do anything. Like you're basically like doing grunt work. So when you work for the city, you're like I tried my first case within 6 months.
Oh wow.
Like I got like major experience right away, and I stayed there for 3 years, and it was awesome. I mean that's where I really, made my bones as an attorney and how to learn how to litigate.
Wow.
And that opportunity would have taken me 10 years in a big firm.
Oh wow, because
So
you're just like a small piece of this big
right,
machine.
exactly.
And so I guess I'm gonna harp on that just a little bit more. I love to ask these type of questions. So what is the relationship of failure with success?
That's a good question. They're opposites of the same coin, right? And I think failure teaches you how to appreciate success, and success, often reminds you of, you know, how to avoid failure.
Mm.
I mean, I think people are successful if they really understand what they do well and focus on that and understand what, deficits they have perhaps that they can improve. So,
Wow, thanks for talking about that. And I do want to kind of dive back into law. And so you worked at that small company, and then wait, I want to get back to that. So you worked at the company, you worked for the city,
mhm.
years on, and so how did you get here at the Phillips?
So, from Corp Counsel's office, I then went and worked at a couple of firms on the defense side,
Okay.
actually representing companies,
Okay.
against individuals in employment discrimination cases. And, I found that I really didn't like that as much because I've always enjoyed the David and Goliath struggle, sort of, helping the little guy, taking on big challenges. So after doing that for a few years, I went out on my own and started my own plaintiff's practice.
I just want to go back into the defense side, representing the companies. Did you find, was there any moral issues that you had to face? Did you find, or
I mean, look, I wouldn't say moral issues, but certainly issues of just personal comfort. Everybody's entitled to legal representation, even a company. And that's how our system works, right? It's an adversarial system. Both sides need attorneys. And ultimately, everyone is trying to get to their version of the truth. That's what the process is.
Okay.
But when you're on the side of the company and you're essentially beating up the individual, right, which is what you have to do in the litigation process, it just doesn't feel good for some people.
And I just spotted something very unique. You have worked on the defense side.
Yeah.
So you also know the tricks and the movements that they're
Yeah.
going to pull. Oh,
Yeah,
wow.
yeah.
I really want to come to you. Wow, that's really great.
Yeah, no, it really does help to have the other side's perspective. So then after doing defense side for a few years, I went out on my own and started my own practice. And then I was lucky enough to join now one of our big competitors, Outen and Golden, which is also a large plaintiff side employment firm. And I joined Outen and Golden, and they have now like 50, 60 attorneys, probably a few more than we do. And they've been in this space for like going on 25 years, long time. We've been around for 10 years. So then I joined Out in Golden as the first associate. It was Out in Golden and me. And then I became a partner, and then we brought on associates and more people, and then the firm grew. And then I handled this big glass ceiling case against Morgan Stanley called Shefflin versus Morgan Stanley, which ended up settling for, I don't know, 54 million or something like that. We co-litigated it with the EEOC. And from there, I ultimately ended up here.
Okay, actually, since we hopped on failure and adversity, so when you have an success like that, big win, now what's your mindset going forward? And do you want to repeat? Is the mindset to repeat that? Are you just content with that and say, okay, that's not going to happen? Like, now, once you have that big win, what's your mindset moving forward?
Well, I think, you have to find the things that drive you. I mean, for me, it was that I wanted to practice law in my own way and service a particular type of, employment discrimination case and a particular type of clientele, which is really the individuals. That case, that Shefflin case, was a class action case brought by the EEOC. And it's not that I have anything against class actions, but I really like working with individuals. So I decided that I wanted to take my practice in a different direction and really focus on individual cases and bringing relief to individuals who have been wronged in the workplace. And that's what Phillips and Associates does. So.
And you've mentioned David and Goliath about 17 times. Now I'm playing, but you mentioned
About 7, but
you mentioned, and I like that. So what goes into, I'd say, when you're tackling not just in a court case, but just out in general, when you have something, an adversary that you perceive as bigger than you, how do you go about tackling that, and how do you go about going against something that may seem grand or a huge task? When you are the smaller guy, how do you even go about?
Well, as I guess the story of David and Goliath teaches us, a frontal assault is usually not the best strategy. So you have to look at your adversary and see what their not only their weaknesses, but their pressure points, the things that will motivate them to get them to do what you want. Ultimately, what you want is resolution, right? So at Phillips and Associates, we do a lot of mediations. We resolve a lot of our cases pre-suit. We have a reputation for going to trial a lot, if necessary, and we settle our cases for high value. That's why we're able to, garner a high contingency rate. But we're very focused on trying to get resolution for people early on. And the way you do that, especially when you're dealing with a big company, is you need to sort of understand what they're thinking about in them, what risk factors they're considering, and you get them to a point where they want to reach resolution. Mediation is a great process for that.
So just to kind of capture that, you said understand their perspective on what they want to achieve, and also attack from. You said attack pressure points. What's attacking pressure points in a legal sense?
Well, a company might have publicity sensitivity. Might be, for instance, about to go, make a public offering, so they would be adverse to public litigation. So if you know that about them, then you very clearly say to them that you're going to court within a matter of days unless they proceed to meet your demands or at least negotiate with you.
Or certain things like they're about to have a new round of investments, things like that.
Yeah.
Oh, okay. So I do want to get into the claims that you work with in terms of employment law.
Yeah.
And the list goes from age to criminal conviction, disability, national origin, pregnancy, race, religion, sex and gender, and sexual harassment. For me, my perspective, and I might be wrong in this, but my opinion is that sexual harassment is probably the most ambiguous case. It's hard to identify. So how can we Yeah, so how can we identify sexual harassment? Because I think there's a bit of a gray area of what is sexual
Yeah, I
harassment.
know
What
what
is
you
it?
mean. I
Yeah.
mean, you know, sexual conduct is part of human nature, and the thing to understand is that sexual conduct is fine. It's just not fine in the workplace, and the reason that it's not fine in the workplace is because people have their own ideas of what is appropriate and what isn't. So the workplace is supposed to be a neutral atmosphere where you can get your job done, right? So let's define sexual harassment. Sexual harassment is unwelcome conduct in the workplace that sexualizes the workspace in a way that makes an individual feel uncomfortable.
Okay.
It is it comes in two forms. It can be quid pro quo harassment, or it can be hostile work environment harassment. If it's quid pro quo harassment, that means that someone of authority over you is essentially saying to you, you have to engage in sexual conduct with me in some way in order for you not to have something bad happen to you at work, or in order to advance at work.
Okay.
That type of harassment imposes strict liability on an employer. There's really no defense for that.
Okay.
The other type of sexual harassment is called hostile work environment harassment. That doesn't necessarily have to be from a supervisor. It can be from a colleague. And there, it's any conduct that's sexual in nature that is unwelcome by the person who is receiving the conduct, and that is causing that person to be uncomfortable. Now, that type of harassment, the person, the victim of the sexual harassment, has some responsibility to notify the company that this is happening, and then the company has to take prompt and effective remedial action. If it doesn't, then there's a claim.
So what's your advice for, because obviously there's younger companies now, there's different types of culture in different companies.
Yeah.
Some companies a little more formal, type button suits and whatnot, some of them a lot more informal. Conversations can be of, very informal, very personable, very date-ish,
Right.
like. So what's your advice to companies who are, a little bit informal? What would be your advice to them? Say, hey, listen, you should pucker up, because what would be your advice to?
Yeah, so I mean, I'm not in the business of giving
Okay.
advice to companies anymore. I
Oh,
used to
okay.
be, but so I can tell you what I would have said to a company if it was my client when I represented companies in employment law. Now I only represent individuals. So what I would have said to them is that you have to realize that the workplace has to essentially be antiseptic. It has to be free of sexual conduct. That's the cleanest way for the company to really not risk exposure.
Okay.
Now that goes a little bit against human nature, because people. The truth is, we spend most of our waking hours at work, and a lot of people meet at work and have intimate relationships. And there's nothing wrong with that. The problem is having that conduct in the workplace, right? And the other thing I want to say is that maybe a way to understand it from the company's perspective is it's really not, sexual harassment isn't really about sex. It's about the power imbalance. So whenever you have a situation where, especially where a supervisor is engaging in sexualized conduct that may be making a subordinate feel uncomfortable just by the nature of the conduct, you want to stop that, because it's the power imbalance that is working the problem there, right?
Okay.
You've got a supervisor who's engaging in some kind of conduct just because he's a supervisor and thinks he can do whatever he wants or she wants, and it's making others feel uncomfortable.
Okay, and I just have one last question to wrap this up, because I want to make this very concise for someone.
Sure.
First, to someone to identify if they're being sexually harassed, and then I want to go into what they can do if they have been. So, like I said, I mean, from my perspective, I thought sexual harassment is the most ambiguous. It's very not easy, but it's more. I would say it's a bit easier to identify racial, gender, because it's spot on, right? But sexual harassment can be very touchy. I'll give you an example. For what I do, video production, I worked with somebody who had just had to mic up, just like I did to you, mic up, individual. But this person, before he mic'd up this lady, he kind of gave he made the lady feel a little bit uncomfortable reporting on the chest. And I can see how the lady felt a little bit uncomfortable. So I told him, like, listen, this is our job, this is what we do. We're supposed to mic up our individuals, right? So don't try to make anything more than what it is. So, but that's a form of touch where we have to, do, in order to do our work. However, some people say, yeah, I'm sexual harassment. So like, what, if you had to really define what it is make it very concise as possible, what is sexual harassment so someone can identify it for themselves?
Well, in terms of touching, to use your example, I would say that, the policy in the workplace should be hands-off, and that unless the hands are necessary. Like in the example you just gave, it's necessary to touch the other person in order to do your job. So that's appropriate, and I think you gave the correct advice there, which is to sort of just don't do anything to make the person feel uneasy, right? But generally speaking, like in the standard office atmosphere, people shouldn't be touching each other. That's just, a good rule for an employer to have. I mean, it does come down, like I said, to the power imbalance and the concept of unwelcomeness. So if you're doing anything that's sexual in nature, that might offend somebody else, and you're only doing it because you're in a position to do it, right? Because you're a boss or you're a supervisor and you can do whatever you want. That's probably something you should not be doing.
So if it's unwelcome, severe,
or pervasive. Right.
Now, if someone have identified, they're watching the interview and saying, you know what? Wow, what Gerry is saying is really spot on. I think I might, have been sexually harassed, or I might be in a case of sexual harassment. What are some steps that individuals can do if they think, they're not really sure 100% what they think that they're in a sexual harassment case?
So this goes not only for sexual harassment victims, but workers who feel that they're being discriminated against on any basis, right? The number one rule is know your rights. And, there are plenty of excellent websites where you can go and you can learn a little bit about employment discrimination and what your rights are. Most plaintiff side law firms like ours, will give you a free consultation. If you think you have a problem, call a competent lawyer, a good lawyer, and ask whether there's an issue there. So number one, know your rights. Number two, which might be a little counterintuitive, is if you suspect a problem, go on record. Email is a wonderful thing. Email human resources and say, X, Y, and Z is happening to me, and I think I may be the victim of discrimination, sexual harassment, etc., and can you help me? The reason that's important is because most anti-discrimination statutes also have an anti-retaliation provision. So when you go on record and complain about your legitimate concern of sexual harassment or other employment discrimination, you're automatically protected from adverse action. Otherwise, you're an employee at will. You can be fired for any reason or no reason or an unfair reason. You have to have some legal protection, some legally cognizable claim. So going on record does that for you.
So going on record, speaking up, and speaking up goes well into this next question, right? Now, recently there has been a surge of this Me Too movement. And from your perspective, how has, just in terms of people speaking up, people walking through your doors, the more calls you've gotten, how has the Me Too movement had an influx on the people speaking up, and have you received more phone calls ever since this happened? Do you feel as if people are speaking up more about these services?
I think certainly people are much more aware of their ability and their opportunity to speak up about sexual harassment. I think where I haven't seen as much of a change as I would like is on the other side. I still think that companies are especially Fortune 500, Fortune 50 companies, for the most part, are still dominated by male hierarchies. Those male hierarchies don't understand the kind of discriminatory gender biases that are ingrained in their institutions. And it takes a long time for culture to change. I certainly think that women have become empowered by hearing their sister voices and getting out there and saying, this is wrong, this has to stop. But it's going to take some time before that really changes the way that companies do business.
And I wanted to ask you, one of my final questions was if you had to diagnose a solution, because ultimately, whether you're on the side of business or the side of the plaintiff, you don't want to see these cases happen. You want to limit them. For sure. You want to help people out. So if you had to say, if you had to diagnose a solution that can be helpful to both parties, what would be a way we can start reducing these numbers?
Well, I think it just comes down to being decent. I mean, I think that whether you're religious or not, I'm agnostic. I'm not particularly religious, but I do think the golden rule is a good one. So do unto others as you would be done by. If you're a man in a position of power in any kind of business environment, treat your female colleagues the way you would treat your mother or your sister. Not, don't engage in conduct that might, if there's even a possibility, if you're a man and there's even a possibility in your head, oh, that might be inappropriate, just don't do it. It's not something you should be doing. And the only reason that you're doing it is because you're in a position of power. I think for women, women just have to keep, pushing the envelope and speaking truth to power and saying to corporate power structures, hey, until you elevate women so that they really have equal place at the table, they're all boardrooms are 50-50 male female as the population is, you're not going to change the culture enough so that the workplace is really gender neutral and not biased against women, because women do the same job as men and are paid 70 cents on the dollar, something like that. They're constantly subject to sexualized conduct, and yet they advance, and they're also culturally and biologically more responsible for raising families. So it's just going to take time for there to be true gender equality in the workplace.
You think we're heading in the right direction now with the...
Well, I hope so.
Okay. So one thing I admire about lawyers and police officers in general is that you kind of see the less pretty side of humanity, right? So, and what I do, I film the good side of humanity, right? So we're on a kind of complete opposites on that spectrum. So what motivates you to continue doing this, even though it might be difficult at times, or what motivates you to continue being a lawyer? And what motivates you now?
So I mean, I really enjoy helping people and being impactful. And the thing that's really great about my particular practice area, plaintiffs' employment work, and focus on behalf of individuals, is that a lot of the time, someone comes into my office, they've just been fired because of a discriminatory reason, and their whole world is upside down, and they feel beat up and worthless or upset, and within a relatively short period of time, I can get them relief, within a matter of months sometimes, even weeks occasionally. I can get them a result that gives them closure and, shuts that unpleasant door and opens up the next door of their life. And being able to be part of that and in a relatively short period of time is great. Now, some cases don't go like that, and you have to, if you fully litigate a case to trial, it could take 2 years. But there are rewards there as well, because there, ultimately at a trial, you get to speak truth to power. You get to, do that David and Goliath struggle we were talking about before, and hopefully you get a good result. So I enjoy being impactful and helping people out.
That's great. And this is the final question I like to ask all of my guests. It's going to be pretty interesting. Urgency or patience?
That's a very good question. I would say both, and I'm not being a lawyer, but I think that, look, Aristotle, I'm Greek,
Okay.
like the Greeks. Aristotle had a saying, all things in moderation.
Okay.
I've modified that saying to be all things in moderation, including moderation. So I think that to be a good lawyer, you have to know when to be urgent. And I would say that if you want to say what the predominant force is, it's urgency. Yes, you're an advocate,
Okay.
you're being urgent a lot of time. But sometimes you need to be patient.
Okay.
Like it's when you're negotiating,
Yeah.
right? There's a saying in negotiation, don't be afraid of the silence. You state your position and you just wait.
Okay.
You don't want to be jumpy, right? So both, mostly urgency, but occasionally strategic patience.
And I never asked this question, probably like a long time actually. What would you tell yourself when you were just getting started in law school, entering your first day of class at law? What would you tell yourself if you had a chat with young Gerry?
Hang in there, it's going to get better.
It's gonna get better. Okay. All right. And last question I'd like to ask all of my guests. New York in one word.
New York is bold.
Bold. Oh, that's a really good one. I like that for sure. Thank you so much. And would you mind just explaining to the camera where people can find your services at if they feel that they need notes?
So Phillips and Associates, our main office is at 45 Broadway. Our number is 212-248-7431. We have offices in White Plains, Garden City, Princeton, New Jersey. We're opening up an office in Miami soon. And our website is NewYorkCityEmploymentLawyer.com.
Brilliant. Thank you so much for tuning in. And if you are watching this, if you feel that at the slightest that you need to seek professional advice, then please reach out to Gerry. And thank you guys for watching this video. Please be sure to watch more videos. And thank you and be great. Cheers.